Now, this is the topic that I'm very excited about because this is what I actually use in order to assign my contracts over to a potential buyer. So let's go ahead and get started. If you'll take a look at my screen, you'll notice that I have, of course, the name of the contract, which is the agreement to assign the Louisiana. I am located in the state of Louisiana. Before you actually structure your contract, you want to make sure that you speak with your legal team, with your attorney, to make sure that this is something that you can actually utilize in your state. You don't want to use something that is not legitimate or legal in your area. All right, so with that being said, let's go ahead and get started. So I have in this agreement is made between you. This is going to be your LLC. So what I've done is I've taken the liberty to highlight all of these specific sales that you need to make sure that you pay special attention to. Of course, in addition to the legal language. But I want to explain the difference between an assigner, for example, and an assignee. So your LLC or your entity or the name of your business, or if you're using just your name, which I actually recommend that you form some type of legal entity in order to get started in this, because you don't want to run into any legal risk later on. But this is going to be your LLC. You are going to be the assigner. The assigner is going to be the person who actually is assigning the contract over to another person. So in this example, it will be the assignee, which is going to be the buyer. So let's talk a minute about what a property wholesaler actually does. And I guess I should have started with that, but let me go ahead and explain to you what a property wholesaler does and what the steps are. So a property wholesaler is someone who actually acts as the middle person between the seller and the buyer. So the property wholesaler actually goes out to try and seek different sellers to see if they're interested in selling their homes. And if they are, then they enter into an agreement called an agreement to sell. And I'll have that link somewhere down in the description, or link it here or there. All right. So the assigner is going to be you. You're the property wholesaler. So you are going to be assigning the rights of that contract that you've entered into with the seller, which is going to be an agreement to sell and a purchase agreement. You're going to assign those rights of your contract over to an assignee, which is going to be a buyer. So that buyer is going to enter an agreement to assign with you. And so this is where we are. So that buyer is going to be the assignee. So this agreement is made between your LLC, the assigner, and the buyer LLC assignee regarding the purchase of the referenced subject property below. So I have put in 123 Sample Street, whatever your city, whatever your state is, and the legal description. So you can actually locate the legal description by going to your local county assessment office, or you can utilize propstream, which is what I utilize in order to find all of my deals. And it provides me detailed information on all of the properties that I'm getting ready to sell or that I'm interested in trying to sell. Okay, so whereas your LLC, which is the buyer, have entered into a purchase agreement with your seller. So as I mentioned before, you actually have an agreement to sell with your seller. You also have entered into a purchase agreement with the seller. So you and the seller have these two contracts together. At the bottom of the purchase agreement, you're going to have and/or assigns, but that's another video that I will do or have already done. I got to look back in my archives and check and see. So whereas your LLC have entered into a purchase agreement or sale with your seller. So you actually going to have the seller's name listed here, whereas buyers wish to assign its rights, interests, and obligations in the purchase and sales agreement. It is hereby agreed between the assigner and the assignee as follows. The buyer and assigner hereby assigns all rights to said contract for sale and purchase to the buyer. So this is the language, this is the legal language that you're going to need in your contracts to show that you're assigning the contracts over to this assignee. So I've used buyer LLC as an example. In exchange for compensation in the amount of, and I'm just going to use this example. So let's just say, for example, that the seller wants to sell their home for $80,000. Okay. You have decided that you want to sell the house for $100,000. So you sent that information out to all of the buyers, the potential buyers. You have a buyer now who's willing to purchase it for $100,000. And so you're entering into this agreement to assign for that $100,000. So although you're entered into the contract with your seller for $80,000, you are saying in this contract that you're also going to be paid a $20,000 assignment fee payable to your LLC to be paid at closing. You don't want to rely on a buyer to actually pay you later. You want to rely on that buyer paying you at closing. So you're going to have your purchase agreement and this agreement to assign that you're going to send to their designated their designated title company, whomever they're interested in closing with. You're going to send both of these documents, the purchase agreement and the agreement to assign, over to their title company, outlining that you're going to be paid a $20,000 assignment fee. So this is showing transparency to the buyer, letting them know that, hey, you're actually buying this property for $80,000 and you're actually paying me a $20,000 assignment fee. Once they sign, then that's solidifying that they're interested in actually paying you that $20,000 assignment fee. And again, like I said, you're sending it up to the title company. I never actually discuss with my buyers beforehand how much my assignment fee is, because I personally feel that if you tell them too far in advance, then they may actually say, well, let's negotiate a little bit more. I don't want to spend $20,000 on an assignment fee. But if you tell them this property is worth, in this example, this house is for sale for $100,000, the comps are $200,000. Of course, you're going to have to be doing your homework and making sure that you're running the comps to find out if this is actually going to be a good deal before you actually send it out to any investor or a person who may be interested in buying houses. So if the comps show that this house is worth $200,000, they're getting it for $100,000. Typically, they don't mind paying that $20,000 assignment fee after the fact once they find out how much the assignment fee is. But if you say, hey, this house is for $100,000, they say yes, then they'll see whenever they get ready to sign the contract that this is actually how much the assignment fee is. You want to be transparent. You don't want them to find this out at closing. You don't want them to find this out much later. You want them to find out now so that everybody can be on board with the fees. All right. So let's continue. So the assignee will pay all of the closing costs. Typically, that's how I hook my buyers, so to speak, because they don't have to actually pay closing costs. They don't come out of any out-of-pocket expenses other than unpaid taxes. And so they like the fact that they're saving on realtor fees. They're not actually having to pay out of pocket on anything. So the assignee will pay all of the closing costs. That's the buyer again. Additional terms and conditions of the assignment are as follows: that there is no risk of loss, meaning that this is all of the lingo that you actually need and want to make sure. I'm not going to say this is all you need, that you want to make sure that's in your agreement to assign contracts, because you want to be, again, transparent as possible. Risk of loss, this property is going to be in an as-is condition. As-is condition, okay? If subject property is damaged prior to transfer of title, buyer has the option of accepting any insurance proceeds with title to the property in an as-is condition, or of canceling this contract and accepting the term with any deposits if applicable, all right? Prorations, real property taxes will be prorated based on the current year taxes without allowance for discounts, including homestead or other exemptions. As I mentioned before, the taxes will be paid by the seller in terms of any prorated taxes. So let me tell you what I mean by that for those of you who are beginners. So a prorated tax is, let's just say that this is the month of October, okay? And that seller has had the property from January all the way until October. So they will be responsible for paying January through October's taxes. November and December will be the responsibility of the buyer. So at closing, a reputable title company will recognize how long of an ownership the seller has actually had, and they will prorate the taxes so that the seller will pay from January to October, and the new buyer will pay from November to December. Okay. If you have any questions on any of this, make sure that you drop it down in the comments. If you like the information in this video and you find it helpful, like and subscribe for more. Whether it's on wholesaling or any other type of questions that you actually have, feel free, like I said, to drop them down in the comments. All right, so let's continue. Disclosures and acknowledgments. Now, we talked about having this on an as-needed basis, but we go a little bit further. Seller sells property as is with no warranties of property conditions. Assigners make no representation to the buyers or his agents as to the condition of the subject property. Assignee acknowledges and agrees that he or she is purchasing the property on an as-is basis and based on his or her own inspection, investigation, and evaluation thereof. Assignee is not relying upon any representations of the assigner's, seller, or seller's agents to investigate and report on the condition of the property. Assignee agrees to hold assigners harmless, defend, and indemnify assigners from and against any and all claims, liabilities, losses, costs, damages, and or expenses associated with the agreement and or the property incurred after the effective date. This language right in this particular paragraph is very important because you don't know if the basement has any issues. You don't know if it's not insulated. You don't know any particulars unless the seller discloses them to you. So in that agreement to sell, on that video that I highly recommend that you watch, you are covering yourself by having the language in that agreement that says that the seller is going to disclose anything that may be going on with the house. It's no different than when they actually have a realtor and that realtor asks for the disclosures, okay? So it's your responsibility to make sure that you have that language in the agreement to assign, covering yourself, saying that, hey, seller, you need to provide this information to me. You need to provide that information to the buyer, okay, as well. But the buyer has their own responsibility to make sure that they are doing their 15-day inspection, okay? So we'll talk about that in a moment, all right? Assigner or sellers do not warrant that the property meets any current city, county, state, or federal building codes, as well as the presence of any and all outstanding or pending violations against the property. So you're further saying, I don't even know if it's up to code. I don't know if it meets any of the codes or standards based on the city or state that we live in. Okay, so you want to be able to have an out. You want to be not held liable for anything if anything comes up later. No judgment. Seller warrants that there are no judgments threatening the equity in subject property or bankruptcies pending or contemplated by any title holder. Again, this language covers you. Radon gas and lead paint. Okay, a lot of homes, way back in the day, had radon issues and lead paint issues. So again, that agreement to assign is going to remove you from any liability on this. Again, you want to make sure that you speak with your legal person to make sure that they go over the contract to make sure it's legal in your area. Licensure, another very important thing that you want to make sure that you have in your agreement. The member or members of the above referenced LLC may or may not hold an inactive real estate license. You want to be transparent that you're not a realtor because you're not. You are a property wholesaler. You will be collecting assignment fees. You will not be collecting realtor fees. So you want to make sure that you are transparent with that, and that licensure clause here covers you so that you won't have the Realtors Association, for example, coming after you saying that you're trying to act in the capacity of a realtor. Possession of the property and occupancy. Tenants accepted with all keys and garage door openers will be delivered to the buyers when the title transfers. And I'm just reading the, first couple of sentences. You can, of course, read a little bit more. But this also talks about the possession when possession actually takes place. When you go to closing, this is typically where the keys and all of that is transferred to the new owner. But you have times where the seller is not always a residential homeowner. They can sometimes be an investor. So you may be actually wholesaling for another investor to another investor sometimes. All right. So this is explaining when the possession actually happens, when it occurs. If you have a reputable title company, it all occurs at the title company. The assignee acknowledges receipt of legible copies of the original contract for sale and purchase in its entirety, including all addendums associated with this transaction. Seller will be notified of assignment. So it's very important for you to make sure that the purchase agreement that you signed with the seller actually transfers over to, or you provide that information over to the buyer so that they can see everything that has been outlined in that purchase agreement so that they can ensure that they are in agreement with whatever you and the seller have agreed on. Of course, before you get to the agreement to assign, you will have discussed and provided all this information to them, okay, before they actually get to this agreement to assign stage, okay? Inspection period is within 15 days from today's date. Contingencies, sale of property is subject to inspection. So just because, and a lot of times this happens, sellers assume that, okay, I'm under contract, that, okay, now my house is definitely going to be sold. But that's not always the case. The case is that something can easily happen during an inspection period. So they don't need to put all their eggs in one basket. You as a property wholesaler don't need to put all your eggs in one basket. I can remember when I first started that I was like, oh, okay, I have 5 contracts under, under contract, but 2 of them actually fell through. So something can happen along the way. It could be inspection period. It could be contingencies. It could be a whole host of things. So you want to allow that buyer to be able to have the opportunity to go and look and inspect the property or hire someone to see if there's anything wrong with the property. A contingency, for example, is going to be, for those of you who are new, a contingency is going to be the seller and the buyer. They may either or say, I'm just going to say the buyer says that the roof has to be fixed. So a contingency that is going to be included on the purchase agreement says that before the property actually goes into closing, that the roof has to be fixed. Or a contingency for the seller may be must close within 10 days or 20 days or whatever it is. All right, let's continue. Sellers, again, if you have any questions, feel free to drop them down in the comments below. Seller is responsible for all closing costs if for any reason they no longer want to sell the subject property once the title search has begun. So a lot of times you will have a seller, well, sometimes, I'm not going to say all the time, you will have a seller who is interested in changing their mind, which they have the right to do so. However, once the title has actually begun, somebody has to pay for those costs associated with the closing. So you want to outline to the seller that they are responsible for actually making payments to the title company once the title search has begun. That's in the agreement to sell. You need to make sure you have that language in there. Finally, we say whether it's located in the flood zone so that we can all have transparency to know whether it's in the flood zone. And again, the assignee is going to be the buyers. So the dates are going to be very important. Make sure you have those in there. You as the assigner, you need to make sure that you sign and date. If there are any co-wholesalers that are included in this, you need to make sure that they sign as well, meaning if you enter into a partnership together to wholesale a particular property, a home that's a seller may actually have more than one person that's on the mortgage that will need to sign off on it, because you want to make sure that you have every party in agreement. And that's pretty much it. That's the agreement to assign. I hope you found this information helpful. Please like, subscribe, follow, all of the above. Have a good day and happy wholesaling. Thanks for watching. Talk to you soon.